good afternoon, and welcome to Industry Insights. My name is Gethin, and I'm the founder of ITERATE. We're a purpose-driven product design consultancy here in the UK. And today, I'm thrilled to be joined by Michelle Ward from Indelible IP. Hello, Michelle.
Hi, Gethin.
Welcome. It's lovely to see you.
Thank you. You too.
So, we're not here to discuss the budget today, but we are here to talk about many of the misconceptions that exist around design registration. But what I'm really keen to do is to jump straight in and understand a bit more about Indelible IP, just in terms of who you are, what you offer. And actually, I really love the name Indelible IP. So just trying to understand how you sort of came about and how you identified that particular business name.
Okay, so I'm a chartered trademark attorney. So the core of what I do is actually in the world of trademarks, which is an area of intellectual property. The other key area is patents. But both patent attorneys and trademark attorneys tend to also cover the area of design protection because it sort of sits and straddles the two. And we both also tend to advise on copyright. So intellectual property is quite an interesting web of different types of rights that often overlap and can sit side by side in the same product. So as a chartered trademark attorney, I've been in the profession for over 30 years. And over that time, I've worked in big law firms, big IP practices, but I set up Indelible IP just over 9.5 years ago,
Wow.
really to help, really to help small businesses get a better understanding and better access to IP advice in the areas of trademarks, design right, and copyright.
Okay.
So that's really my background. And Indelible IP, well, as a trademark attorney, the thing I couldn't do was get the naming of my business wrong and end up conflicting with someone else. And I kept having all these brilliant ideas and then finding that someone else had the same brilliant idea. So my husband actually came up with the idea on the basis that in the old days, you used to make your mark on papers and it would be indelible. And so the name Indelible IP kind of stuck.
Very good. Very good. So in terms of the three different forms of IP that you just talked about, copyright, trademarks, and design registrations, which area do you work most in? Is there a top one or two that the majority of your work comes from?
Yeah, I mean, the majority of my work does relate to trademark protection. So along with patents, it's generally seen as one of the key areas of protection. Copyright tends to come up only alongside areas of trademark and design right, largely because it's an automatic type of right. So it comes into existence as soon as something's created. So there's no registration process. So we only tend to get involved where there are dispute or ownership issues. Design right is an interesting one because it sort of sits somewhere between trademarks and patents. People get very excited about the brand they're going to put out into the marketplace. They get very excited about protecting the technology behind their innovation. And somehow along the way, the concept of design right, which protects what your product looks like, gets a bit missed. But in actual fact, it's a really valuable type of right to have. And certainly at present, it's a very simple type of right to get in the UK.
Okay. So when we say design right or design registration, just for maybe some people that don't know, and even for my clarity, what are we talking about here? What does it exactly involve?
Okay, so design right is used as a general term to cover both registered and unregistered types of right. We have quite a complex regime here in the UK. So we have registered design protection, and before Brexit, we also had an EU registered design system. Now that still exists, but it doesn't extend to the UK anymore. And so at Brexit, all the EU registered designs that were in existence at the time were
Hmm.
converted automatically into UK designs. So we have a UK design registration system, but we then also have an unregistered design right that was introduced in the Copyright Designs and Patents Act in 1989, and that protects a slightly different area with a slightly reduced um,
Okay.
uh, time period in comparison to a registered design. But also courtesy of Brexit, we have taken on an EU unregistered design right, and this has now exists in the UK as a supplementary unregistered design right, which again has a very different regime to original UK unregistered design right. So we have this very complex web at the moment with a
Hmm.
slight twist thrown in with some copyright law that covers works of artistic craftsmanship. And there
Right.
is actually a big consultation underway at the moment with the Intellectual Property Office that closes tomorrow, because they're looking at making a number of changes to the design rights system in the UK. And one of those is to try and get some clarity and some streamlining of these different regimes, because it's complex.
Hmm.
And when you've got the advisors who are sat there saying it's complex, I fully appreciate that for people who are not experienced in this area of law, it's going to seem like a complete and utter minefield. So there is this big desire to simplify the process as well as to make some other significant changes to the system.
Yeah. Wow. Yeah, naively, I didn't appreciate how complex the system was that kind of sits behind design registration. I think maybe the assumption, certainly for me and possibly for others, is that patenting a product is a highly complex process and very involved in getting a patent granted, and that maybe in some instances design registration or design rights are kind of easier. It's almost like it's maybe even lower valued in some cases that it may be considered. So I don't think I appreciated the infrastructure that sat behind it and some of the complexities. But would you agree with that observation that may exist out in the market? The difference between design registration and patents, and the fact that um, maybe they are the child of the IP world.
Yeah, so they're sometimes referred to as a Cinderella right
Okay.
because they're kind of completely undervalued. Um, so firstly, we have in the UK what is often referred to as a deposit system. It's relatively inexpensive to get a design registration. And so quite often people think, well, look, just need to throw in a few images, pay a little fee, and we've got a design registration. So that tends to be the first error. And then the second one is also that I don't need to worry about what my product looks like. I'm just worried about how it works. That's the thing that I need to protect, or I need to protect the brand. And actually, we make a lot of buying decisions on what things look like.
Yeah.
So what your product looks like actually can be very relevant. And although design registration is about external design features,
Okay.
unregistered design protection under the UK unregistered design rights system also protects internal features of design. So again, this is where the intricacies of where these rights sit and how they overlap with each other can become quite complex.
Okay. Okay. So an unregistered design right is when you create a product and you put it out into the market, and that visual or that form is novel in nature. And are you suggesting that you automatically have a right over that particular form without even having to go through a registered design process? Is that correct?
There are some rights. They are shorter in term. They're governed by a different set of
Right.
rules,
Okay.
and there has to be actual copying for there to be infringement. Whereas if you have a registered design, something that is independently created, not actually copied, can still be an infringement of your registered design. So that there are some differences there. And also, a registered design has a much wider scope of things it will protect. So the UK unregistered design right system only protects features of shape and configuration, whereas the registered design system also protects things like pattern, ornamentation. It extends to things like graphical user interfaces. So
Okay.
it's got a much broader ambit. So it often gets applied to things like packaging and things like that.
And so when a design registration is filed, what needs to actually be shown? Because I know that, and maybe we'll come on to this shortly, but there has been lots of historical disputes where maybe some design elements haven't been included, or people have assumed that they have been covered. So when you're advising your clients on preparing or getting together the documents to file a design registration, I mean, what should they include? How, how do they provide that? Is it a 3D view, multiple angles, like an isometric drawing, or what's the best way to provide that imagery?
Okay, so there are a number of different formats that are quite acceptable, and it could be line drawings, it could be CAD drawings,
Okay,
it could be photographs. There are some basic rules, don't have extra things in there. We've seen plenty of them where people have put their product on a patterned cloth, patterned background,
wow.
fingers pointing at things. Um, that's not going to help you, because whatever is in the image is what is protected.
Okay,
And that defines the sort of the parameters and the scope of your protection. So yes, historically there have been some strange ones. The intellectual property office are a little better now about pulling people up on those, and they do have some basic guidance on what should and shouldn't appear in images. But the thing to actually think about, and to a certain extent you need to understand how design infringement is assessed, is um, what is the element that is the new appearance, the new design that you're trying to protect. It could just be a part of the product, in which case you're going to want your
okay,
design focused on that particular part. But also think about, what are the variations? What are the obvious variations? So don't just file one view, don't
hmm
just file one version. There's an option to file multiple versions within the same application, and you actually only pay a fairly small incremental additional amount for doing that. So if you know that if you can already say, oh, well, we could also do it this way and we could also do it this way, why not actually go and get the design protection for that? But there has to be
okay,
some thought and care into what the key thing is that you're trying to protect, so that the best way to actually capture that can be thought about, and also, what those variations are. How many variations can you instantly think of? Because what you don't want to do is to make it easy for someone to come up with an alternative variation. So
hmm
that it will, that what you need to do will differ on each each new design. But it's not just a case of take a couple of images or a couple of CAD drawings and throw those in and think, great, Bob's your uncle, I've got brilliant design protection now. Because the case law shows us that that's not necessarily going to get you the best result if you do have an infringement. um Equally, think about, you know what is it that you're not showing? Is that actually something that's critical? And even think about things like, how shading is shown, because cases that are out there tell us that actually that can be really significant. And the other important thing to understand is that it's not protecting the concept. It's protecting the specific design that's in the image, and it's protecting the specific appearance that's there.
Okay, interesting. So yeah, that very much leads into strategically how do you use your IP? So you're talking about not just protecting the design that you intend to put out into the market, but all of the possible variants around that to be able to mitigate competitors from creating something similar. I've heard of people filing patents to stop competition bringing similar products to market, but I do like that idea of filing multiple versions of a particular design. So when you talked about really trying to focus on the novel aspect of a product that you'd be interested in protecting, I'm imagining that if you've got a product that's got multiple parts within that, would you still um, include the entire product assembly within the submission, or would it literally be this component within this wider assembly is what we really need to hone in on and protect?
You could potentially do both. So you could potentially put the complete component in there. Um, if they're component parts, you need to think about in use, will they be visible? Because that's going to be one of the requirements for it having protection. So
Right.
unregistered design right will cover internal components, but for a registered design, you're talking about the things that are visible in normal use.
Okay. Okay. Yeah. So it's what the user would see then potentially that's where you need to put your focus.
Yeah.
Is there such thing as too much detail?
Um, there can be. I mean, obviously, each case will hinge on its own specifics. But obviously, if you have so much intricate detail in there, the test that's applied for infringement is different overall impression. So if you put a humongous amount of detail in there,
Hmm.
then it's not going to take too much change to that detail to create a different overall impression. So yeah, you could potentially go into too much detail.
Okay. Okay. So I think the case the excuse the pun, but the instance with the trunky ride-on suitcase was quite synonymous with design registration. So what I'm interested in understanding there is did that instance change the way that design registration is used now? Because from my understanding, that the Trunky being a UK-based business, that there was a Chinese competitor that created something very similar to the Trunky product and sold it into the UK market. So that was quite a landmark case, but has it changed the way that people use design registration or file design registration in any way? Is there key learnings from that?
So, as a profession, obviously, we had quite a few key learnings from it. Um, I think the primary problem was that the concept of the trunky was obviously very unique. At that time, there wasn't
Yes.
really anything else out there.
Hmm.
So, by filing a fairly generic and basic visuals in the design registration, obviously the expectation was that they were putting in something very unique, and therefore anything else that came along that looked fairly similar was going to end up being an infringement because it wouldn't necessarily create the test being a different overall impression. Um, so the problem was that um, the design showed a very um, simple or basic is not the right term. A very bare kind of look to the design. So it was real bare basics. And some of the imagery, because it was shown in black and white, and with grey shading, it showed sort of uh, slight differences. So some bits were grey, so it showed tonal differences where
Hmm.
the light was catching things differently.
Hmm.
So then the court had to look at what were the key design features versus what were the key design features in the what was called the kiddie case. Now, the kiddie case had an awful lot more um, characterization and ornamentation on it. So when the comparisons were made, you had one that in the case of the trunky was described as looking sort of like a stylistic horned animal, whereas the kiddie cases were these very cute little characters. They had faces, there was striped patterning and all this sort of thing
Interesting.
to show, and a very specific type of animal, but in a very cutesy type of way.
Hmm.
So although
Hmm.
they were using the concept of a ride-on case, the look of them was actually very different. And I think that was then where the court took great care to look at um, the what was in the what we call the design representations or the
Okay.
images that had been filed on the design registration. And so this, for for us as professional advisors, what had been thought of within the profession as the best way to approach design protection was definitely given a shake up, because it meant that it was much more important to be having those conversations about what is it that you're trying to capture. And so obviously it may well have been a better scenario to have put in far more versions and variations of the trunky design
Hmm.
in order to potentially capture more or more that would give a closer similar impression with those types of infringements.
Okay. Okay. And as well, I think there was quite a significant case between Apple and Samsung, and was it because of the same kind of reasons, or was with the nature of that, was that very different?
So I think the nature of it was very different, and in actual fact, the UK design infringement case was just a minuscule part of a massive international dispute between Apple and Samsung that
Okay.
covered a lot of patents. In the US, it covered something called design patents, and um, they were looking at some really intricate detail of the way that design infringement is assessed. So we have to look at something called the informed user. Who's the person who's actually going to be looking at this and going, oh, that one looks very similar to this one? Are you talking about a highly specialist technical product, in which case you're talking about highly specialist technical users, or as in this case, you're talking about people who are your day-to-day users of these types of devices because they're a heavy consumer product. You have to look at what's called the design corpus. So what's already out there, and how much of a change do you have to make for it to give what's called a different overall impression? And you also have to take into account design freedom. If your product essentially has to have certain components within it, and a certain particular approach to shape and features that are on there in order to fit into that category of product, then your actual um, creative freedom is actually quite limited. So ultimately, on the design infringement side, in the UK, there was a finding that Samsung hadn't infringed Apple's design, but
Okay.
obviously, cross cases, they had all sorts of other claims going on where some were finding in favor of Apple, some were finding in favor of Samsung, and it rumbled on for a very long time. But this is the difficulty with design infringement. There's so many things that have to be taken into account.
Okay. Okay. So we're coming up to 5 minutes, and I know there's one or two people have had their hands up, so we can take some questions in a second. But what I would just like to cover off was you mentioned that the design registration process is going through a period of consultation at the moment, which is due to end tomorrow, I think you said. So what's likely to happen? I mean, have there been any giveaways, or have you maybe got some predictions or insights as to how the design registration process is likely to change? Because I think that could be useful for people here.
Yeah. So one of the key things they're looking at the moment is the fact that they believe there is a statistically significant number of invalid design registrations, either because people have filed them without realizing that they're filing something invalid. So for a design registration, it either has to be not public at the time of the application or have only been public within the past 12 months. For UK purposes, those rules don't necessarily apply elsewhere. It's a general principle you need to file before it becomes public. So some of the concerns they have is that some people are rather unscrupulously filing design registrations for existing designs or other people's designs and then using them to keep them off certain selling platforms.
Okay.
And then obviously people have to take action to remove those registrations. So at the moment, the design registration process is deposit. As long as you are fulfilling certain basic administrative criteria, you will generally get a design registration within a week or so of filing. There is no review of existing designs. And I think that's the thing where we're likely to see the biggest change, that somewhere in the procedure, or one of the options is that you need to have this search and verification before you can enforce it.
Yeah.
We're going to see something that's going to tighten up on that. And so there will be a little bit of a more complex process. It may make it a slightly more costly process, but I think that ultimately people want something that they feel that they can actually rely on when they really need it, which is to stop somebody who's infringing. So to have greater certainty over the validity of your right. And therefore for other people to have greater certainty over the validity of those rights is probably going to be one of the biggest changes we have, along with the sort of the streamlining of the different regimes that we have in the
Yes.
UK on unregistered and registered rights.
Okay, very good. Thank you. So I can see that Philip has got his hand up. Philip, would you like to ask a question to Michelle?
Yeah, thanks, Gavin. And Michelle, thanks very much for a fascinating canter through where we are with design registration. I've got two very brief questions, if I may.
Please.
One is UK registration against European registration. Is there any sort of direction in which you would advise a small business to go in terms of the benefits of each? And I'll come to the second question afterwards, if I may.
Sure. Yeah, so these days, if you want protection in the UK, you need a UK registration, and if you want protection in the EU, you need to go for an EU design registration. Pre-Brexit, you could file an EU design registration and you automatically got the coverage in the UK, but it's not the case anymore. So it really depends on where your market is.
So ostensibly, as a UK manufacturer, if you were selling in Europe, you'd need both.
Yes. Yeah.
The second question, sorry, it's slightly off topic, but in a former life at the patent office, one of the things we did for small businesses was advise them kind of unofficially that they were far better taking out trademark protection rather than patent protection for novel things, to try to establish brand and gain ownership of their product in that way. Is that kind of still a valid approach, or is that sort of not really the right thing to do?
I think the thing is that sometimes it's about having speed of protection, and because you will get a trademark registration significantly more quickly than you would a patent, and significantly less expensive than you would a patent. It really depends on what the thing is that people see as most important. Sometimes, the drive is the brand and not the innovation itself, because it's seen as something which is too fast moving. But there's not a case of only do one or the other. But I think with small businesses, it tends to be more budget. So design registration sometimes kind of helps to kind of bridge that gap a little more, but it's still not protecting the underlying innovation.
Brilliant. Thank you very much. Thanks, Gethin.
Thanks, Philip. A question from Tom in the chat. Should design registration therefore be started at the same point as applying for a patent? One concern I have is during a patent application, I would typically include a diagram of the product I design. If granted, the design would be in the public domain. Typically, my clients opt for patents first, then UK design registration, then expand design registration using the Hague system.
So there is this issue with publication. So with a patent, it's confidential until when it's published at 18 months. I'm not a patent attorney, but I do happen to know that's the publication point. So yes, design registration, because generally it will be published very quickly. There is a deferment period for publication that you can request, and that is one of the things that's in the consultation to review that, because in the UK it's 12 months, in the EU it's 30 months. So we're looking at possibly moving to an 18-month period. But yeah, you do, and also changes may be made during the development process, which maybe can be encompassed within the patent more readily. But once with a design, if you put it out there, you've registered it and it's public, then yeah, you kind of potentially messed up the patent position.
Okay. Tom, I don't know if you've got any follow-up questions, or is that good?
That's great, thanks. Sorry, I've got a really sore throat.
No problem, no problem. And just one final point from Paul. When is it best to bring the patent agents in the design process? I think the question here is earlier the better.
Earlier the better. Then you're not necessarily talking about filing these rights from day one, but the more involved they are, the better your chance. At the right point, you're going to be looking at whether it's patent protection, design protection, trademark protection. I know most businesses, usually the sort of the product development is done by a different team who then marketing. And so obviously you also need some internal liaison between them to make sure that the marketing team don't overstep the mark or jump the gun. And potentially, everybody's going to have different pools on budget.
Okay. Okay, brilliant. So thank you very much, Michelle, for joining us on Industry Insights today. And thank you for everybody that has also joined the session today and asked questions. Very grateful for your involvement. Today will be the last Industry Insights of this year. We'll be back in January with our monthly event. And as always, we're looking for new and interesting people to talk to just for half an hour about different areas of product design, manufacturing, innovation, intellectual property, to help keep us up to date on all of these changes and innovations within the market that we're all very fortunate to be involved with. So thanks again, Michelle, and hopefully see you soon.
Thanks very much.
Thank you.
Thank you.